situation when you are being charged for something you did do. Today, we're diving into Rule 117, Rules of the Court, Motion to Quash. What is motion to quash? A motion to quash is a formal request to a court to invalidate a legal complaint or information, which can be filed at any time before the accused enters a plea. It must be in writing, signed, and specified, which can include the facts not constituting an offense, lack of jurisdiction, the complaint defect in form, or issues like the visibility of offenses, distinguishes liability, or previous acquittal. If the defect is curable by amendment, the court will give the prosecution a chance to amend the document before deciding on the motion. In Rule 117, Section 1, time to move to quash. At any time before entering his plea, the accused may move to quash the complaint or information. In Section 2, form and contents. The motion to quash shall be in writing, signed by the accused or his counsel, and shall distinctly specify its factual and legal grounds. The court shall consider no ground other than those stated in the motion, except lack of jurisdiction over the offense charged. Section 3, grounds. The accused may move to quash the complaint or information or any of the following grounds. A. That the facts charged do not constitute an offense. B. The court trying the case has no jurisdiction over the offense charged. C. That the court trying the case has no jurisdiction over the persons of the accused. D. That the officer who filed the information had no authority to do so. E. That it does not conform substantially to the prescribed form. F. That more than one offense is charged except with a single punishment for various offenses is prescribed by law. G. That the criminal action or liability has been extinguished. H. That it contains a vermin which, if true, would constitute a legal excuse or justification. And I. The accused has been previously convicted or acquitted of the offense charged, or the case against him was dismissed or otherwise terminated without his express or consent. In Section 4, amendment of the complaint or information. If the motion quash is based on an alleged defect of the complaint or information, which can be cured by amendment, the court shall order an amendment be made. If it is based on the ground that the facts charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion shall be granted if the prosecution fails to make the amendment, or the complaint or the information still suffers from the same defect despite the amendment. Section 5. Effect of sustaining the motion to quash. If the motion to quash is sustained, the court may order that another complaint or information be filed except as provided in Section 6 of this rule. If the order is made, the accused, if in the custody, shall not be discharged unless admitted to bail. If no order made, or if having been made, no new information is filed within the time specified in the order or within such further time as the court may allow for good cause. The accused, if in the custody, shall be discharged unless he is also in the custody for another charge. Section 6. Order sustaining the motion to quash not a bar to another prosecution exception. An order sustaining the motion to quash is not a bar to another prosecution for the same offense unless the motion was based on the grounds specified in Section 3, Paragraph G and Paragraph I of this rule. Section 7. Former conviction or acquittal, double jeopardy. When an accused has been convicted or acquitted, or the case against him dismissed or otherwise terminated without his express consent by a court of competent jurisdiction upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction and after the accused had pleaded to the charge. The conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charged, or for any offense which necessarily includes or unnecessarily included in the offenses charged in the former complainant or information. However, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information under any of the following circumstances: A. The greater offense developed due to supervising facts arising from the same act or omission constituting the former charges. B. The facts constituting the graver charges become known or were discovered after a plea was entered in the former complaint or information. Or C. The plea of guilty to the lesser offense was made without the consent of the prosecutor and of the offended party except as provided in Section 1, Paragraph F of Rule 116. In any of the foregoing cases, where the accused satisfies or serves in whole or in part of the judgment, he shall be credited with the same in the event of conviction of a greater offense. Section 8. Provisional dismissal. A case shall not be provisionally dismissed except with the express consent of the accused and with notice of the offended party. The provisional dismissal of offenses punishable by imprisonment not exceeding 6 years or fine of any amount, or both, shall be permanent 1 year after issuance of the order without the case having been revived. With the respect of the offenses punishable by imprisonment of more than 6 years, their provisional dismissal shall become permanent 2 years after issuance of the order without the case having been revived. Section 9. Failure to move the quash or to allege any ground therefore. The failure to the accused to assert any ground of a motion to quash before he pleads to the complaint or information, either because he did not file a motion to quash or failed to allege the same in said motion, shall be damned in a waiver of any objections based on the grounds provided for in paragraphs A, B, G, and I of Section 3 of this rule. That's it. Rule 117 can be your shield. Stay informed and know your rights. Don't forget to share this video.